So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Let's fire someone in Armenia. Today we're going to be talking about the termination of employment there. It's an interesting country near Iran, Georgia, Turkey, and it's really at the crossroads of a lot of different civilizations. And it's a really interesting one. They share a lot in common with the United States, but then in addition have a lot of different things. So this article is from Concerned Dialogue Law Firm, and I didn't want to butcher their names because some of the names I do have a trouble saying, but you can go check out the link down below if you'd like to read more about this. So let's get started off. You can fire someone in the case of liquidating a company, of course, non-compliance of the employee with the position held or the work performed, reinstatement of the employee at their previous job, so you can get rid of them if they want to go elsewhere. You can get rid of them for periodic non-fulfillment of an employee, which means just they're not doing their duties assigned to them. In addition, loss of trust, which that one I'm curious, like how much you have to. That one I'm curious how much you have to establish. Loss of trust is pretty big. Same thing with whether or not a person is refusing or evading the mandatory medical exams. I mean, they seem very basic for me, but it is what it is. I mean, that's at least you can terminate someone for at least some reasonable cause. The next one up is the rest of them you can do dismissal if they go to the workplace under the influence of alcohol, fail to show up for no valid reason during the entire working day, which that's actually pretty. So there are no rules in the United States with respect to as long as you're not terminating someone in a discriminatory manner, there's no real rules, but on a federal level at least. But many companies don't even fire for that, right? But in the United States, I think I've only worked at one that had a no call, no show, immediate no call, no show as termination. And whether or not they reach age 63 and entitled to a pension. And I think this is pretty interesting. There are a lot of mandatory retirement ages out there. Most people in America are not aware of this, but it is something that exists. And it's really unusual and something that uh, Americans wouldn't know anything about. You know, frankly, we would consider it age discrimination to do so. Again, it's a little bit curious to me. I'm sure that it helps with their hiring and making sure that you have someone in terms of economics, making sure that you're hiring younger people. You know, you can't then you don't have to worry about sort of offboarding retirement age employees if maybe they've gone past it or whatever. I don't know. I mean, I do think that I wouldn't want to work in a country like that. I think the people that are over the age of 65 or 63 have a lot of use and a lot of value that they can provide. And so removing them from the workforce seems a little bit odd. This next one is one that I really wanted to dig into. Which is they excluded from work for more than 10 consecutive working days or more than 20 working days during the previous 3 months because of their failure to submit the necessary documents required to attend work during isolation declared in relation to the pandemic. That's really interesting that you can fire someone for that. I mean, it's very specific. America obviously did not get that specific, especially with the COVID pandemic. And the next one is that you do need to give employees notification before dismissal. But when so for example, when your company is laying off and the company is ending, you have to give employees 2 months notice. But you can pay in lieu of notice, which is pretty common. Pay in lieu of notice is a pretty standard practice in much of the United States. As well, I mean, it's not in law in the United States at all, but it is practice for employers to terminate someone immediately once they've given notice and then just pay them out for those days. The next one up is whether or not there's a requirement for severance pay. There is when an organization is liquidated, when number of employees are reduced, or if the employee is reinstated at another job. But there is severance pay, and in addition, there's severance pay if an employee has a long-term inability to work. But it's based on work experience and daily salary of that employee, which is pretty interesting. Finally, the times that employees are protected from dismissal are during a temporary period during which the employee is unable to work. That I'm fairly familiar with. It's effectively illegal in the United States as a gray area. Because ADA protected leave could be possible. It is possible. Of course, period of leave taken by the employee. Don't know if that's akin to FMLA or something else, but that is, similar to the United States as well. Employee's pregnancy definitely illegal to fire during that, assuming that it's for the pregnancy itself and not, I don't know, a mass layoff or something like that. And then it just has to be non-discriminatory. Implementation of duties imposed on the employer by the state. So they have some sort of rule. It's like that in the United States as well. Period of natural disaster. We can terminate in the United States for that, as well as a period of unplanned transfer or unplanned provision of holidays provided for educational institutions if the employee did not show up for work to organize care for a child under the age of 12. I think that's probably related to the COVID pandemic, but I don't know that for a fact. And then it says, you can't dismiss an employee when an employee who is not on leave takes care of a child until the child turns 1, and after decision on a strike is adopted, and during the strike if the employee takes place. So you can't, and that is effectively illegal in the United States. It depends. It could be a manipulation or a play with the National Labor Relations Act potentially. So very interesting. I think that this is a lot of good information. The last one is mass terminations. So there are procedures for it. If the company is liquidated, the employer must notify the state employment service and the employee's representatives at least 2 months in advance. So you do need to, it is effectively like a WARN Act in the United States, and you always have to notify the union, which is not, it's on a contractual basis rather than a specific law. In addition, you could do a collective action or lawsuit. So let me know what you think about Armenia, about its termination laws, and how it compares to the United States. And let me know, leave a comment down below, and we'll see you on the next video. Bye, guys.